Welcome to Cheating Story Lab, titled Step-Parent Adoption Court Date Set. In the parking lot of my daughter's soccer practice, I found myself fixated on my phone as my hands grew numb. No call from my ex-wife. Instead, she filed adoption paperwork without a word and let the court inform me like some distant acquaintance. Her new spouse, a man I had met only twice, sought legal guardianship of my children, aiming to obliterate me, usurp me. Yet while he intended to replace me as their father, I remained alive, battling, present. I had 60 days to respond, and that's when the decision was made which would alter everything. I wouldn't dispute my parenting skills in court. I wouldn't defend my fatherhood against her fabricated claims. Instead, I decided to delve into the man who sought to supplant me, uncovering truths that made me comprehend my children had been in danger for 8 months. My name is Owen. This narrates the account of how I thwarted a predator from legally claiming my kids. Part 1. 4 years ago, Melanie, a flawless substitute, parted ways with me, marking the end of our 11-year marriage that began in college and bore us 2 children, Kitlin, who was 9, and Mason, who was 7. The divorce was as brutal as it was unsurprising, given that she had been involved with a coworker for 14 months, a secret I only discovered when Mason saw them kissing in the garage and questioned why Melanie's friend was giving me kisses. That day marked the demise of our marriage, but I believed my role as a father to be unshakable. I was mistaken. The initial custody arrangement was 50-50, but Melanie proved shrewd. She diligently documented every instance of my tardiness for pickups, every missed school event due to work conflicts, and every moment where I fell short. By the 2nd year, she had primary custody. By the 3rd, my parenting time was limited to alternating weekends and 1 weeknight dinner, and I continued to contest. I drained myself financially for lawyers I couldn't afford. I reorganized my work schedule to optimize my time with my children. Family court values documentation over effort, and Melanie had been meticulously documenting since her decision to depart. Subsequently, she encountered Garrett Finch 6 months into their relationship, a professional, well-groomed individual working in medical device sales. He regularly attended Mason's baseball games and took Kitlin to school events when Melanie was working. On paper, he seemed the ideal stable father figure that court desired. We only crossed paths twice, once at a school fundraiser where he complimented the children and expressed pride in them, and another time at Kitlin's birthday party, where his proximity to Melanie and familiarity with Mason made him feel incongruous, stirring an uneasy intuition within Melanie. Later, the adoption petition emerged. The court documents were impersonal, stating that Garrett Finch aimed to adopt Kitlin Renee Morrison and Mason James Morrison. Melanie's affidavit alleged my participation in the children's lives was minimal, with Garrett taking on a primary parental role. She argued adoption would offer the children stability and permanence they needed. There was a space for my approval. If I didn't act, the court would proceed regardless. I contacted my attorney, Patricia, who had stood by me since the initial custody battle. She was costly, frank, and the sole individual in the legal system who seemed to genuinely perceive me as a competent father. They can't do this without establishing abandonment or unfitness, Patricia said. I am involved, I provide support, I exercise my visitation rights. This is unusually aggressive of Melanie. Can we halt it? We can contest it. However, the Owen family court tends to favor stability if they can demonstrate Garrett has been the main father figure for the past 2 years while I've been absent. I've been absent because she manipulated the system. I understand, but the judge won't see it that way. That evening, I found myself in my apartment, scrutinizing the petition before me. Its tone left me feeling inconsequential, like a mere footnote. As the biological father with minimal interaction, I pondered my role, the one Kitlin still called every night to bid good night, and Mason, who expressed his desire to live with me when he grew older. I recalled Garrett Finch's firm handshake, the way he addressed my son as Buddy. However, a decisive moment arrived. If Melanie was intent on removing me, I needed to identify who would take my place. Not merely his surface self, but his past, his secrets, everything. I embarked on this quest, beginning with the fundamentals. Public records revealed Garrett Michael Finch, aged 38, born in Ohio, boasting an unblemished criminal record in our state and a clean driving history. LinkedIn presented a stable career in medical sales, while Facebook showcased him and Melanie at vineyards, hiking trails, my children's sporting events. It seemed almost too idyllic, prompting me to invest in a comprehensive background check service typically utilized by private investigators. The expense amounted to $400, an amount I didn't possess, yet I felt compelled to find out. 3 days later, the findings were unveiled, revealing the first inconsistency. Garrett had resided in Ohio until age 23, but for 2 years following, there was no trace of him, no address, no work history, no records whatsoever. Then, he resurfaced in Pennsylvania with a fresh job and an unblemished record. It's unusual for someone to vanish for 2 years unless something significant occurred. I reached out to the background check firm. The agent, a woman named Iris, was polite but cautious. Absences like Garrett's are often associated with sealed records or expunged cases, which we can't access without a court order. What kinds of cases get sealed? They include juvenile offenses for individuals under 18 years old, plea bargains where the record is hidden as part of the agreement, and sometimes relocation programs. It varies. Could you inform me about the states he lived in during those missing 2 years? The records indicate he obtained a Pennsylvania driver's license when he turned 25, but unfortunately, that provided no additional information. I expressed my gratitude and ended the call. I subsequently conducted searches for court cases in Ohio under his name, focusing on civil and family matters rather than criminal ones. I discovered a case, Garrett Michael Finch versus Ohio Department of Child Services, filed when he was 22. The case was listed as dismissed, but the records remained public. It was a request to remove his name from the state child abuse registry, which was denied. In my car outside my office, I reread that particular line multiple times, realizing my ex-husband's new partner was listed on Ohio's child abuse registry and seeking to adopt my children. That night, I stayed awake, poring over my laptop at the kitchen table, plotting out all the information I had gathered. Garrett Finch was on the Ohio Child Abuse Registry. His petition for removal was unsuccessful, and eventually he moved from Pennsylvania to our current state. Why wasn't this appearing on routine background checks? I phoned Patricia the next day to gain clarity about child abuse registries, particularly Ohio's. After a brief pause, she clarified that Garrett Finch was indeed on a registry but had attempted to have his name removed, which was denied. Another pause followed, and she asked, "Are you certain?" I had located the court case. A longer silence ensued. "If he's on a registry and is in proximity to your children, that's why I'm contacting you." "Isn't this supposed to show up? Don't registries cross state lines?" Patricia sighed deeply. "It's intricate. Some registries are public, others are only accessible to specific employers. If he's on Ohio's registry but resides in our state, he's theoretically required to register here too. However, enforcement is inconsistent and people frequently evade the system. What should I do? You should report it promptly to CPS in our state. If an adoption petition is underway and the potential adoptive father has a history that could compromise child safety, Child Protective Services, CPS, can investigate. I contacted CPS about this matter. In the afternoon, the intake worker seemed weary. I stated that I wanted to report a child safety concern. My ex-wife's partner is seeking adoption of our children, and I discovered he's listed on Ohio's Child Abuse Registry. Worker requested details, to which I provided Garrett's full name, date of birth, the Ohio case number, and the adoption petition number. She assured me that an investigation would be initiated. Someone will get in touch with me within 72 hours, but whether this halts the adoption is up to the court. However, if we uncover credible safety concerns, we'll submit a report to the judge. I ended the call and felt the first glimmer of hope I'd had in months before continuing my investigation. I found 2 additional questionable aspects in Garrett's history. One in Pennsylvania, where he worked at a youth sports facility for nearly a year before suddenly leaving with no explanation provided in public records. I contacted 2 places where Garrett Finch had previously been employed, including a private school in Maryland and a sports facility. The sports facility refused to comment, while the school's HR department stated they couldn't discuss former employees. However, a former colleague from the Pennsylvania facility was found on LinkedIn, and I messaged him regarding my potential hire of Garrett Finch for a child-related position. He had worked there a few years prior. The response came 2 days later, stating that Garrett left under unclear circumstances, with an incident involving a parent complaint. Management had asked him to resign, and he was not recommended for youth work. I took a screenshot of the message, then contacted Iris again, a background investigator, asking for a comprehensive 50-state check on every place where Garrett Finch had resided or worked in, to uncover any other registries, cases, or relevant information. $2,000 is the cost. I will proceed. I depleted my emergency fund, halted retirement contributions, sold my car for a less expensive one. It was all for my children's protection. Money held no value. The investigation spanned 3 weeks, totaling 73 pages. Garrett Michael Finch had 3 records related to child safety in databases from 3 states. Ohio's was the oldest, dating back to when he was 22, involving a substantiated case of inappropriate behavior with a minor in a coaching setting. Despite no criminal charges being filed, his name was permanently added to the registry. Pennsylvania's record was more recent, stemming from a complaint by a parent regarding boundary violations with a child at a sports facility. The investigation ended inconclusively, but Garrett resigned prior to its conclusion. His name was flagged in the state's database as unsubstantiated yet troubling. Maryland's entry was the most recent. In the third part, it was discovered that Garrett Finch had been rejected from a private school due to a previous child abuse and neglect record in Ohio. This was uncovered during an FBI fingerprint check. Prior incidents in Pennsylvania and Maryland also raised concerns about his suitability as a parent. 3 weeks after the report was filed, a Child Protective Services, CPS, investigator named Denise Holt contacted me to inform that Garrett Finch is on Ohio's Child Abuse and Neglect Registry, with violations of interstate reporting requirements. Furthermore, there were 2 other concerning incidents identified in Pennsylvania and Maryland. Now that you know this information due to the adoption petition, I'm unsure if Melanie was aware or chose to disregard it. I'm submitting a family court report to the judge handling the adoption case, suggesting they reject the petition and order a comprehensive custody evaluation. Additionally, I'm reporting Garrett to the state attorney for neglecting to register. The sensation I felt was rare. It was relief. Will Melanie learn about this before the hearing? She'll be informed that CPS has submitted a report. Details will only be disclosed during the hearing. The adoption hearing was set 63 days after receiving the initial petition. I entered the courtroom with Patricia, carrying a 73-page investigative report and Denise Holt's assessment from CPS. Across the table sat Melanie, Garrett, and her lawyer. Confidence radiated from Melanie, while Garrett seemed composed as if he had already won. Judge Lorraine Mayers, nearing 60, presided. She served for 20 years and is known for her meticulousness and lack of sentimentality. She leafed through the file. The adoption petition filed by Garrett Finch concerns minor children linked to Owen Morrison and Melanie Finch. Mr. Morrison has raised objections. In response to a query, Denise Holt explained findings from Child Protective Services. In our investigation, we discovered that Mr. Finch is enlisted on Ohio's Child Abuse and Neglect Registry due to a substantiated case of inappropriate behavior with a minor in 2009. He has neglected to comply with the legal requirement for registration within the state. Furthermore, 2 other instances from Pennsylvania and Maryland were unearthed that raised doubts about his aptitude for parenthood. Melanie looked pale, but Garrett remained unmoved. Judge Mayers directed her gaze at Garrett. Mr. Finch, were you cognizant of the necessity to register in this state? Garrett's lawyer responded. Your Honor, my client was not privy to the interstate registration requirement. My response does not answer your question, Mr. Finch. Judge Mayers questioned Garrett. Were you aware you were listed on Ohio's registry? Garrett hesitated before answering. Yes, Your Honor. The judge then asked, did you reveal this information to Ms. Finch prior to moving in with her and her children? After a moment of silence, Garrett replied, no, Your Honor. Judge Mayers turned to Melanie and inquired, Ms. Finch, were you cognizant of your partner's registry status? Melanie answered tearfully, no, he led me to believe his past was clean. The judge pulled out a CPS report and read aloud. This document details 3 distinct incidents spanning 3 states where concerns about Mr. Finch's behavior with minors were raised. Garrett, why should I grant you the adoption of 2 children when multiple states have flagged you as a potential risk? Despite Garrett's lawyer attempting to interject, the judge continued. The Ohio case is nearly 16 years old, but my client was still a minor at the time. He lied about his status to the mother of these children. He failed to register as legally required and applied for adoption knowing he had disqualifying factors in his background. Judge Mayers shut the file. The request for step-parent adoption is rejected. Additionally, I'm mandating an instant custody review for the present arrangement between Mr. and Ms. Morrison, she addressed Melanie. Ms. Holt, organize with the court evaluator to ensure Mr. Finch's background is factored into the evaluation. Looking at Melanie, she advised, Ms. Finch, I urge you to reconsider your living situation. If your partner might endanger children, that affects your custody rights. Melanie was weeping. Garrett fixed his gaze ahead, his jaw tense. The judge then turned to me. Mr. Morrison, I'm approving a temporary alteration in custody until the evaluation is complete. He added, you'll have equal parenting time from next week. We'll reconvene in 90 days. I nodded, struggling to speak as we exited the courtroom. Melanie clung to my arm in the corridor. Her eyes were swollen. Were you aware? She asked quietly. Before the adoption petition, did you know what he was? I replied, no. She sensed danger and felt compelled to safeguard them. She released my arm and departed, leaving Garrett near the elevator, our gazes momentarily locking. He seemed to regard me as if I had taken something from him. Without uttering a word, I reciprocated his gaze. The fallout from the custody assessment spanned 4 months. The court-appointed assessor interviewed me, Melanie, Garrett, the children, their teachers, pediatrician, and thoroughly examined Denise Holt's CPS report. In the end, the recommendation favored me. The evaluator opined that while Melanie was a competent parent, her neglect in thoroughly scrutinizing her partner and prioritizing the children's safety over the relationship raised significant doubts about her discernment. The assessor suggested reinstating 50-50 custody with mandatory supervision whenever Garrett was present. Melanie accepted this decision without contestation. 2 weeks following the assessment, she instructed Garrett to vacate the premises. She might not have challenged him over his deceit or perhaps couldn't bear to acknowledge the harm he inflicted on our kids' lives. Regardless, he was absent, and gradually they adapted. Kitlin inquired once about Garrett's absence, to which I disclosed the truth suitable for her understanding. Adults sometimes err in trusting people, and your mom and I prioritize ensuring you and Mason's safety above all. Mason didn't inquire. He merely appeared relieved. Half a year following the adoption hearing, I regained equal custody of my kids again. I coached Mason's soccer team, attended Kitlin's piano recitals, helped with homework, bedtime, and Saturday morning pancakes. I was their father once more, not because a court ordered it, but because I defended them when they couldn't defend themselves. Melanie and I have limited interaction. When we do, it's about logistics, pickup times, school events. We maintain a polite distance now. She is aware of what almost transpired. Garrett Finch was indicted for not registering as a child offender in our state. He admitted guilt and paid a fine, then left the state soon afterward. I don't know his current location, and frankly, I don't care. What truly matters is that my children are safe. They spend half their time with me, and they understand that I will always defend them vigorously. This is what counts. Sometimes people inquire if I regret the intensity of my struggle, whether I should have agreed to the custody arrangement to avoid conflict. My answer is always no, because I realize this. The system does not automatically secure your children's safety. It safeguards order, paperwork, and whatever appears most secure on paper. If I hadn't delved into Garrett's background personally, hadn't spent money I couldn't afford on investigations and legal fees, hadn't urged CPS to scrutinize further, he would have legally adopted my children, thereby effectively erasing me as a parent. This was not because I was an unfit parent, but because I failed to fight strongly enough to demonstrate my worthiness. Thus, if you find yourself embroiled in a custody battle or concerned about who your ex is exposing your children to, heed this advice. Trust your intuition, investigate thoroughly, document everything, and stand up for your cause. Remember, the system won't safeguard your kids. You must do so. And if anyone ever seeks to supplant you as a parent, ensure you know their true nature first, because I did, and it likely saved my children's lives. This is Cheating Story Lab. Thank you for tuning in.